Okay, so good afternoon to you all. As we are getting started, I just want to shout out to Camille. Whatever you can say about the Paris Olympic, it was a cultural fest, and there's no denying a multicultural fest, but it was a beautiful one. And I want to give kudos to the Europol agents at IRU and the French who have done such a great job at this Olympics. So I just want to set that right. It was important for me. But I would like to welcome you to something different. It's a panel on law enforcement and national security in the fight against serious crime and terrorism. My name is Torsten. I'll be moderating this panel. I work for a civil society organization based in Berlin. I focus on rights, surveillance, and democracy. And I would like to thank the organizers for inviting me to this very, very interesting conference. And I'm even more thrilled to welcome 3 practitioners to this panel, all of whom have profound knowledge, one would say, on the front line of law enforcement and data protection and fundamental rights and basic freedoms. And they have agreed to join me on this panel. So thanks so much. I would like to welcome Erin Prest. She's a Privacy and Civil Liberties Officer with the FBI. Jürgen Ebner, who is Deputy Executive Director of the Governance Directorate and Security Coordinator at Europol. Welcome to you. And Thomas Zedek, who is Head of Unit Supervision and Enforcement of the European Data Protection Supervisor, EDPS. Good afternoon to all of you. We have about 16 minutes, I think. At least we have to catch up some minutes, I guess, because we're running a little bit late. But we are focusing on a very timely, complex, important, and very broad topic. So we need to narrow it somehow. And I want to give you a brief context. Doubtlessly, our democracies are facing genuine and grave threats, both from within and from outside. And the legitimacy of our states depends on their effective provision of security for the people. And this is the task of national security and law enforcement agencies. And for this, they need adequate mandates and resources. And yes, this does include access to data and the processing of personal data. And unlike authoritarian regimes, democracies need to make sure that such access to data is not unconstrained. It is not disproportionate. It's legally mandated. And this, some of you may say, is a timeless challenge with the evolution of technology. And it requires frequent recalibration. And the good news is we're not alone. We can learn from other democracies. We're in dialogue. And this is what we're here today to do. And so I've agreed with each speaker that they have more or less 8 minutes to come up here and present an issue or an agenda item that is very dear to them. And we start with Erin, then Jürgen, and then Thomas. And then I will follow on some aspects with a discussion. Then we open the floor to hopefully a interactive debate. We don't have a game. We don't have PowerPoint discussions, but we have very, very interesting topics. And I would like to ask for your attention. Thank you so much. Erin.
Good afternoon, everyone. So yes, as to kind of speak on a topic near and dear, I'm actually going to take a few minutes, though, to kind of set the stage a little bit, just because I think it'll be important as we kind of go into the more substantive topics. So first of all, a little bit just about myself. As he said, I'm the Privacy and Civil Liberties Officer for the FBI. I've been that now for almost 7.5 years. But I've been with the FBI for almost 18 years total and started on the national security side. Most of my work these days is really a split between the law enforcement side and the national security side. The FBI has both. I am also the Deputy General Counsel on the criminal side of the house, but under the privacy officer hat, I do a lot with national security in terms of looking at tools, systems, operations, and kind of trying to find the right spot for us as an organization in terms of protecting individual rights, liberties, and the mission of the FBI. So to take a step back a little bit about the FBI specifically, we have the broadest investigative authority of all US federal law enforcement agencies. As I mentioned, we have a law enforcement hat where we're looking at things like white-collar crime, organized crime, human trafficking, things of that nature, as well as the national security side, where we are lead for counterterrorism, counterintelligence. We have other missions as well on that side. And it's really a combination of laws and different authorities from the Attorney General, executive orders, and statutes that give us this kind of combined mission authority. So for us at the FBI, we are within the Department of Justice. And through that, we have Attorney General guidelines for domestic operations. We also have, and that's about 50 pages, which is a good amount of material, but nowhere near scratches the surface on what a law enforcement or national security agency can and cannot do. So we have taken that 50 pages and we have multiplied that into something that we call the Domestic Investigations and Operations Guide, which is available for the most part publicly and online. But that is several inches thick and is probably about 1,000 pages and really kind of walks through, for us, what can you do at what stage of an investigation? What authority do you need to have? What information or predicates do you need to have before you can do different things? And part of that is because citizens have a reasonable expectation of privacy. And, but also there's a legitimate need for the government to protect individuals from criminal actors. And so we try to find, and I hate to say balance, because often people think of balance as one or the other. You're sacrificing one thing for another. I don't mean balance in that way, but more of an equilibrium. You have to have pieces of both. You have to have the right combination of both things. And that doesn't necessarily mean sacrificing one thing for the other. But the FBI is a large organization. It is about 37 or 38,000 people. And we are spread out across the world. So we have what we call field offices in every single state in the US, but we also have a number of offices overseas. And so trying to kind of get a handle on what all of those folks are doing and making sure that they are doing things appropriately and in the right way means that we have to have lots of layers. And we have to have lots of things that are really baked in from the moment they start at the FBI. So one of the first things you do when you start at the FBI is you take an oath to the Constitution of the United States to uphold the rule of law. And that really starts and kind of frames things for people in terms of all of the training and everything they will get from that point on is about how to do things the right way, how to do things in a way that protects civil rights, civil liberties, privacy, but in a way that also gets the mission of the FBI accomplished. So as the privacy officer, I'm a direct report to the director of the FBI. But I also sit within the Office of General Counsel. So I have that dual reporting structure, which I can have and will probably at some point use again, where when needed, I go direct to the director. If there's an issue, if there's advice that needs to be given, strategy that needs to be given, that's not an issue, I go direct. But I also can work through our Office of General Counsel, which is very helpful in terms of learning the ground truth. As you can imagine, with an organization of this size, it's sometimes difficult to figure out what exactly is somebody in Anchorage, Alaska doing on their day-to-day basis. So we have it. There is a privacy and civil liberties unit that works directly for me that kind of serves as basically the front line. We have division privacy officers in every headquarters division and at every field office. So that's kind of another line of defense in some ways for us, of people that we train that know the ins and outs so that they know and can help on the ground, but also know when to essentially phone a friend for more complex matters. Like many of you and like many of the topics that we have talked about here, you know, we're all facing kind of the same interesting group of topics of commercially available information, facial recognition, AI. How are we wrapping our hands around this? How are we figuring out where the right place is for our organization? And in some cases for us, what that means is looking at the different tools, looking at how the operators, how the agents on the ground, how do they want to use it? And then working to figure out, okay, you want to do X. I don't think you can do X, but maybe you can do Y if you've got certain information. Or maybe it's, we can try this out in a small, limited fashion and build in additional protections, build in additional mitigations to make sure that we are protecting individual rights in the same way as we would normally. But these are topics that, from talking to all of you, everybody across the globe is facing in terms of how do you make sure that you have the right protections, that you know what the tool is actually doing. Was it trained appropriately? So those are some of the things that we try to figure out kind of on a day-to-day basis. I think for the privacy office at the FBI, we are many ways trying to figure this out at several different levels. As I mentioned, we're looking at tools, we're looking at systems, we're getting calls from the people on the ground about particular operations or investigations, and they're saying, hey, I've got X, Y, or Z, here's what I want to do, what do you think? So we're also providing that kind of day-to-day advice about how this works on a practical level. It's not enough to just say, in an ideal world, here's how this would work, because none of us live in an ideal world. Something goes wrong somewhere, and you got to learn how to figure out on the fly how to fix it, how to mitigate it, and still do what you need to do. For us, as it relates to some of these hot topics, and then I'll wrap up quickly, one of the things I really want to mention is Privacy Act of 1974. As we've sort of talked about, the statutory framework for a lot of folks just doesn't keep up with technology. There is one portion of the Privacy Act that I repeat ad nauseum to folks, which is E7. It says the government shall collect no information about how an individual expresses rights guaranteed by the First Amendment unless specifically authorized by the individual, specifically authorized by statute, or pertinent to or within the scope of authorized law enforcement activity. It's that last pertinent to and within the scope that the FBI usually is using, but that is also very much not a blank check. Folks need to be able to articulate what is their purpose, what is their reason, and they need to have that narrowly tailored enough for what they're trying to accomplish, because you can't just suck up everything in the world or everything in a particular context. It's really got to be narrowly tailored. I think with that, the timer's not working, but I will pause. Oh, now it works. But I'll pause so we've got more time for questions.
Thank you so much, Erin.
Yeah, good afternoon, everybody. From my side, first, thanks to Daniel and his team to having organized this conference. I think it's a good opportunity to really exchange views. And in my statement, I would like to think a bit outside of the box, and I also would like to challenge you a bit with questions. I don't have necessarily answers, but maybe the questions might trigger later on a bit of a discussion. Thank you, Thorsten, for setting the scene, and thank you for the brief introduction of the speakers. There are only two elements I would like to add when it comes to my person that you should know, because that's related to the statement I will make. I am a boomer. I know this is not an achievement, this is just a fact. I'm a boomer. And part of this is really that in the 70s, where I was raised, I'm a truly convinced person that believes in data protection, because I want that my personal data is protected to the best possible way and don't want that this data is misused by companies, governance, or whatsoever. So that is one part. The other part of my boomer being is that I'm now almost 40 years with the police. And in these 40 years, I saw quite some change of the police work and the challenges that are ahead of police work. And you can believe me, in the last 40 years, there was a lot of change to be seen. When I started the police, we hadn't had any mobile phones, laptops or something like this. We had telephones and typing machines. So that is how we did information processing. Big files to be read through and analysis made by marking things and doing summaries of everything. So that is, let's say, where we started, and nowadays the challenges are different. And these are related to this topic of law enforcement and national security in the fight against serious crime and terrorism, which is a very wide topic, but I would like to reflect a bit on what was said yesterday. First, the executive director said Europol has to deliver an effective response to the threats of organized crime and terrorism. She mentioned 3 elements, which are, I think, important. The impact of artificial intelligence on the law enforcement, the lawful access to data and encryption, and third element, and this was also the topic of the panel discussion just before, the disinformation, that can have a severe impact on democracy and society. And I believe that this calls even more stronger than ever before that first and for all, we have to be always ready to adapt of the achievements. And we also have to check, and this was also mentioned by Aaron, thank you for this, that we always have to check what are the available tools that can help also the police to be used in order to deliver the security and justice that is required from the citizens in a lawful and of course data protection conformity way. So that is one element referring yesterday to the presentation by the executive director. Another element which I found extremely interesting was from the president of Slovenia. She was saying it's not only about data protection, it's about protection of trust. And this is particularly important in the field of law enforcement. I would like to give this also a bit more thoughts about the trust, because trust, from my understanding, is a multifaceted and on many elements depending issue. The trust is about what she was speaking about. It's about trust that personal data is protected. There's another element of trust, which is that police is, of course, respecting human rights, data protection, and of course, following the rule of law. This is also part of the trust of the citizens in police. But, and I think this is another element I also would like to add, trust of the society in Europe is also that police is able to ensure a high level of security in the area of freedom, security, and justice. This is also something where people show if they trust the politics, the governance, and the police. And again, to be a bit provocative, if you see in the last months, in many member states, the election results, do you believe that the right-wing shift that we saw is the result of a lack of trust in data protection? Or is this maybe the result, again, to be a bit provocative, that there might be, for whatever reason, profound or not, maybe a suspicion that the politics, the governance, and the police is not any longer able to really to create this feeling of security in Europe for whatever reason. So just a question, not a statement. So what is the, let's say, complementary of our work? I think having this in mind is, and I'm looking really to Thomas and the colleagues of EDPS, is, I think under these conditions, more than ever required that we are able, we, data protection people and police together, to demonstrate that all actors are able to guarantee all aspects of this trust, not just one. We have to really demonstrate that we are able to exactly cater for this area of justice, freedom, and security. So what are the challenges? If I break down now all these elements that were mentioned by the executive director yesterday, in principle, I see there are 2 challenges. The one is complexity. Complexity in the sense there are a lot of interdependencies, first of all actors, but also of all information that is to be processed and to be analyzed. There are a lot of interdependencies. And the second element is really the problem of the ever-increasing amount of data and information to be managed. One element. The second challenge is the speed of our reaction as a consequence of the information society. We have to be simply faster. That is, let's say, the other challenge we have to have. So the goal should be, from the work of police in complementarity with data protection to reduce the complexity, which is, by the way, from my understanding, data minimization. So in effect, data protection as such, and to be faster. And to be honest, and I think this was also discussed, I believe we need the modern technical tools, and this is artificial intelligence. The reality, again, here comes a bit of provocation, is we are working with methods that were fine in the 90s. And with this, we try to solve problems now bashing data protection. This is the same also at the side of police. We have to be faster. So how to do it? How to do it? This is the question. From Europol's side, there's a clear need to respond faster than ever to requests of the law enforcement agencies in their investigations in the member states to analyze data. That is, in fact, the request we are getting in. And in this, most of the time, the request is to reduce complexity, to manage the information that is available, and to focus really the police work on the data that is really necessary. This is, I think, only possible if you look at the big amounts of data with artificial intelligence. Now looking to the EDPS, I think we have to further speed up the process. And here, just some questions, and not to be misunderstood. But have you ever thought about using artificial intelligence from the side of the data protection to analyze massive amount of data to be faster simply to understand what is landing on the table? And have you ever thought about that maybe artificial intelligence in the positive sense for data protection might be even able to detect if police is using artificial intelligence created tools in a biased way? Because artificial intelligence is possible to detect also if something is not going according to the lines and if bias is included in tools. So just a question. So by ending this, just to say, what I would like to see, and I was also reiterating this in front of the European Parliament, I think we have a very fine system, and I fully respect the role of the European Data Protection Supervisor, and we have a good cooperation. They are asking, we are trying to respond. That is the role. But I think there's clearly need of even stronger complementarity of Europol and the EDPS to develop tools and a role that will deliver solutions expected by the citizens of Europe. Thank you.
Thank you so much. Thomas.
Wow. Thank you very much, Thorsten, Jürgen, Aaron. Good afternoon, colleagues, ladies and gentlemen. Thanks for the introduction. Thanks for the organizers for having me. Maybe I start directly with answering in a very resounding yes to Jürgen. Also, the EDPS is actively thinking about introducing AI and using AI. But of course, like you, we had to wait for the adoption of the AI Act. So we're looking forward how to do that. You know what the European Data Protection Supervisor does. We are the Data Protection Supervisory Authority for more than 70 European institutions, offices, bodies, and agencies, including Europol. You know what the EDPS does when we do supervise Europol. We have this good working atmosphere, thanks to you, Jürgen, and my 8 colleagues in the specific sector in supervision and enforcement are very happy to be able to do just that. But I wanted to throw a different light on one of the topics which Aaron already mentioned. I want to share with you a very practical case which happened in our office this year from January. One of those over 70 European Union institutions, offices, bodies, and agencies came to us as they can and asked us a question. They had organized a conference like this one with 145 participants, exhibitors, and they were then approached by a member state intelligence service, by a national security agency from a member state, with the request to hand over the list of all the participants, full names, organizations, from everybody who had participated at this conference. So, like in a situation like we have here today. So this very simple question from the EUIs to us was, can they ask this? Do we have to comply? Can we do this? And of course, as we've heard already in these 2 days, we have the treaties. We have Article 4.2 of the Treaty of the EU. National security is for member states alone. Nothing to do, nothing to see for the European Union, and certainly not for the EDPS, right? So an answer could have been, no, there is absolutely no obligation for a controller to demonstrate compliance with data protection law and principles to a supervisory authority which is not competent. But not so fast. Which law applies? Obviously, handing out this data from the list, this is about personal data, it's a transmission in our world. So which law applies? That is also very simple. The GDPR would apply to a similar event happening in a member state, like border control activities, you have to apply the GDPR. If this was a law enforcement agency, they would have to apply the law enforcement directive. And yes, for national security, you would have national law, maybe on data protection or not. We have clear separations, all is cool. And of course, in our case, we have the EU DPR, which is even better because it combines the GDPR and the law enforcement directive. And we have fantastic case law from our Court of Justice, which states very clearly, I'm almost quoting here, the mere fact that a national measure is based on the purpose of protecting member states' national security interests cannot render EU law inapplicable and exempt a union institution from its obligation to comply with union law. There we go. What does this mean? And this is our advice, which we gave to our client. Look at the EU DPR, because it's about processing of personal data. You have an Article 9 in there, which is about transmission to a recipient in the EU other than an EUI. And Article 9 requires the recipient of that information to show processing is necessary and that this is necessary for a performance in the task carried out in the public interest or in the exercise of official authority by that recipient. So we asked, do we know anything about this? And the reply we got from an EUI was, yeah, they said, National Security Agency, it's a routine check and the rest is classified. Okay, so we told them, well, go ask more, please. Then you also need to show an explicit and legitimate purpose under data protection law. The reply was, they couldn't tell us because they said it's classified. So we had to tell them, like, go ask. And there are, of course, other EU DPR obligations. What's the ground, lawfulness ground, data minimization? Are you making sure that if you want to give out this list, that it's really only about what is necessary, purpose limitation, etc., not to speak of transparency and data subject rights. And there, I even mentioned it for European Union institutions, there is a specific protocol in place attached to the treaties, the protocol on number 7 on privileges and immunities of the EU, which says the archives of a union institution are inviolable. And the Court of Justice has interpreted that in saying basically any document which originated in such an EU institution and which relates to their activities is part of archives. So accountability, we gave the advice to the EU. I said, look, these are the requirements, show that you can fulfill all this, and then you can decide if you want to hand over this list of participants or not. And by the way, it's not the first time that national security comes into play. We all know about Schrems, we know about data retention, there are issues of public procurement, and of course, media freedom, spyware. So national security needs to be looked at from the point of view of European Union law. And data protection authorities in that sense, yes, of course, we are there to protect individuals' personal data, but we are also border guards, like courts, especially the Court of Justice, on patrolling the borders of union law. But, and I think this is a big but, and this relates to what the colleagues on the panel have said, border guards also need to know who and what can or should cross borders. Maybe the National Security Agency had a very good reason to be interested in that list. We don't know. They didn't say. But if that was clear, then our life would be much easier and we could react much faster. Because nothing needs to be sucked up, but you need to know what are the limits. How can we handle this? So I will end it here. Our supervisory opinion on this very practical operational case is public on our website. So go check it yourself. We will take this opportunity to learn more on what happens in these specific cases, because I can imagine that because of the threats, we will have more and more of those cases, and we want to be reactive and we want to be proactive so that in case where it is justified, of course, we have the tools and we can be secured from these external threats. Thank you very much.
Thank you very much, Thomas, for sharing this case with us, and also for you all for sticking in the time limits that we set to allow for a discussion. And I think your anecdote would be interesting, what the National Security Agency, whether it stuck with its request once it had such a well-informed client thanks to your advice or not, but that's for others to look up maybe on the webpage and find more answers there. But I want to start the discussion with a theme. You know, I said we don't play games here, but we do a little bit, softball and hardball. So I think it's a bit of a soft introduction perhaps, but it's important, on the rule and the setup of data protection officers, or as you call them, privacy and civil liberties officers. Aaron, I know, well, my guess would be there is mutual benefits if you have at the internal level civil liberties and data and privacy officers doing their work, and at the external level, independent oversight and accountability mechanisms also working. And to what extent, how would you describe the cooperation and exchanges you have between the FBI, privacy and civil liberties officers and other professionals working on external oversight and accountability mechanisms in the US?
Sure. So we have lots of different layers in the US, both internal and external. Just within the FBI, there's my office, which both kind of gives advice and does oversight. There are other oversight capabilities through our inspection division, Office of Internal Audits, that exists just within the FBI itself. That doesn't even get into the oversight that happens at the Department of Justice level. Through the Office of the Inspector General on the national security side, the National Security Division. As it relates also to national security, you've got the Office of the Inspector General for the intelligence community, you've got ODNI oversight, and then we've got the Privacy and Civil Liberties Oversight Board, Government Accountability Office. So there are lots of different layers, and we work fairly closely with a number of those folks. ODNI in particular, my colleague from ODNI is here. We were talking earlier that I think somebody from our offices is in touch and talking about something every day. We work very closely with the privacy and civil liberties officers across the intelligence community at the various agencies, but we're also in routine contact and communication with, say, the people at the Privacy and Civil Liberties Oversight Board and some of those other oversight entities.
Thank you. And to you, Thomas, so you come from the perspective of an external supervisor, and how do you see, or how you assess the quality? You spoke about those 8 colleagues of yours who are involved in the Europol supervision. And it sounded as if you have very profound and good exchanges. But is there anything, if I could ask, where you would hope for more exchanges, more work going forward when it comes to the cooperation and dialogue between the internal and external data protection teams?
Dawson, I think it's really a question of resources at this stage. There are already requirements to, let's say, prior consult, for example, in Europol, when there are new systems to be set up, when there is a new technology going to be used, you already find a requirement to do a data protection impact assessment. But what we find most useful is indeed to have, if not daily, but very regular cooperation to be able to discuss already at the outset before setting up a system, say, where are you going? Are you sure you know everything? And for that, I agree with Aaron, to have a data protection officer who is able to understand both worlds, both the data protection world as well as the operational requirements. It's a very useful tool, a contact point to be able to say, look, these are data protection requirements, something like data protection by design, very, very useful. But sometimes, as Jürgen said, sometimes things evolve. Sometimes one needs to be reacting very quickly. And for that, you need then also, in our case, more resources to say, yes, this person can only look at the system and give daily advice if need be. If we don't have the resources,
Right.
that is simply not possible.
Okay. And I asked this question because, you know, Aaron, you came in with the Privacy Act and E7. You mentioned Article 9, and these are dry, somewhat, you know, these are legal provisions, but they need to be filled with life. And when they are filled with life and you put interpretations on the table, you see the effect that they can have on practice. And I want to focus on the second theme, on the tools and methods that law enforcement and national security agencies use in the fight against serious crime and terrorism, with a focus on the collection, acquisition, processing of publicly available information and commercially available data. And here a lot of intelligence agencies and national security agencies, they speak of open source intelligence, OSINT, or even ad-int, advertisement intelligence, when it refers to the ad tech industry and the ways you can benefit from the products that are being sold or licensed on this market. And there's a new US strategy that actually speaks of OSINT being the int of first resource. So that's where you first go to in the fight against terrorism and crime, because it's a lot of information is already out there and you can aggregate it, and others can do that also very, very intensely with the use of new technologies and methods. And I want to focus on Article 17, another one, of the Europol regulation. There it says, Europol may retrieve and process information, including personal data, from publicly available sources, including the internet and public data. That sounds pretty innocuous at first sight. Notice in 2009, the regulation spoke about publicly available sources, including commercial intelligence providers. That's no longer here, but you get perhaps where I'm coming and want to go to. So there's much talk about, and rightly so, about data retention. We heard about it yesterday. There's the risk that's being portrayed of going dark because of use of encryption, and some say more stringent regulation is put forward in member states. Yet at the same time, perhaps we're also witnessing a paradigm shift where, yes, there is use of signals intelligence in the national security realm. There is use of lawful interception in the law enforcement realm, and it comes with a number of requirements. But there's a lot of value you can attach to open source intelligence and add-in, and it may not come with the same regulations. And it requires the purchasing of data, sometimes geolocation data, leaked data sets, you know, and there's this notion of being publicly available, but is it really available to the public, or is it the national security services and the police being clients to some of the tools that are being sold on the open market? And some of this has severe interferences with public rights, and there is questions that you can ask about this being sufficiently regulated. And given that, Erin, the US notably has turned its focus on the intelligence community's use of commercially available data and ways to protect Americans' bulk, sensitive personal data from all kinds of nefarious use by foreign adversaries. And we don't need a lot of imagination to think about the different nefarious use cases that there could be. But it also focused on the first element, the intelligence community's own practice when it comes to data purchases. And the privacy liberties offices at ODNI, they played a key role that culminated in a new framework, including the use of sensitive, commercially available information. And for this, it required new protections and safeguards, minimization, which makes it a lot more complex, Jürgen, access restrictions, and also public reporting. And Erin, do you have something similar in place for the law enforcement community?
So yes and no in the typical lawyer answer. So the ODNI framework applies to the FBI as part of the intelligence community. From a practical standpoint, while that might say for national security systems, many of our systems at the FBI are what we call dual use. They are used both on the law enforcement side of the house and the national security side of the house. And while I can think of a couple of systems and tools that are only used on the national security side, I can't really think of the same that are only used on the law enforcement side, which means that basically anything under the law enforcement is also going to fit in some ways under this national security. But the other piece of this is, as I mentioned, we're part of the Department of Justice. The Department of Justice is also working on their own kind of version of this. It's not finalized yet, so it is still to come, but that's one of the things that, because we wear both hats, as we're coordinating and working with the department and we work with ODNI, we're also trying to make sure that we're not setting ourselves up for failure by having two different standards or having standards that conflict when they both apply to the same system.
Interesting. And then, you know, the law enforcement community is huge, both in Europe and in the US, the intelligence communities, many agencies, and it was a need to streamline. If different agencies have a different interpretation of what is commercially available, then you get into a lot of question marks. But where would you say the future role for privacy and civil liberties officers could play going forward when, you know, with the Department of Justice initiatives, what would you like to see develop in the future when it comes to that?
Honestly, our life would be a lot easier if the two sides would talk to each other a little bit more so there's better coordination. I'd imagine for you all, it's a little bit like your member state and the EU writ large, wishing sometimes there might be some additional communication so that you're not trying to kind of bridge those gaps and ferret out those different lines where there may be different definitions, because the different definitions actually matter for you at a very practical level. And I think that's just one of those areas as a DPO, as a privacy officer, like that is going to be an area that continues to grow, especially as we are working through not just commercially available information, but in particular, the AI, as we've talked about here over the last few days.
Thank you, Erin. Jürgen, given what we've heard on the importance of open source intelligence and ad intelligence and the role of the ad tech industry, data brokers, but also the genuine risk to fundamental rights and freedoms that can emanate from this int of first resort. Do you think Europol's current regulation adequately captures what is necessary to prevent unconstrained, disproportionate access to personal data, or is there something that the European side could learn from the US in its attempts to regulate this further?
Thank you. So practical cooperation, transatlantic nature. No, first of all, very, very interesting how this is dealt with in the United States. Two elements I would like to highlight, also Thorsten, to avoid any misunderstanding, because this is still existing sometimes in the political debate. First and for all, Europol is not an intelligence agency. We are not an NSA. So from that perspective, we are processing law enforcement data, first thing. Second thing, we have no coercive powers. For that reason, we don't do any interception, whatever, to collect further data. This is also not possible for Europol. So the main source of the information to be processed by Europol is to be received by the law enforcement agencies of the member states, which, one should also not forget this, they collect this information under judicial oversight, under the national data protection rules. So information processed with Europol has a first control layer at national level, and then we have a specific intake procedure of this information into Europol following the Europol regulation. Now coming back to your question. The regulation, which was updated 2 years ago, from our perception, brought a lot of clarity into what Europol is supposed and allowed to do with data to be processed. You are mentioning the Article 17, I think, and on some elements we have a bit different view with the EDPS, but at least, let's say in the core, the Article 18 is precisely outlining under which conditions Europol can collect data, whether it's so-called data subject-related categorization data, whether it's specific data, whether it's data even another article that is collected for innovation purposes, so doing some research. So it's very clear from our side, this regulation brought in a lot of clarity. And in the core, I would say, all the amendments that are made to the Europol regulation are mainly to bring in clarity for how Europol can process data, what is to be done with the data. And this is even including, and this is maybe going a bit beyond what you said, the open source available data. I think that the best practical example for me is the work that is to be done by the Internet Referral Unit, where you just listened to our colleague, which is in fact implementing a regulation which was developed by the legislator, so the Parliament, the Council, the Commission, the Terrorist Content Online Regulation, where, and this is, I think, is a good example for practical cooperation, where we needed, of course, a technical tool, which is called Percy, where we had with the EDPS quite a debate until this was put in place, but now it's working. So that is for me a part of practical cooperation, where even, let's say, this type of information, where we would say, well, look, this is somehow available on the internet, should be not that complicated to process it, where for understandable reasons, EDPS had a bit of different opinion, saying, yeah, you can process it, but under certain conditions, and you have to follow also certain techniques in doing so. So this was solved. For us, the more important part of the change of the Europol regulation is related to what are we allowed to do with the so-called cooperation, and then, of course, information stemming from private parties. Because there's a point, I would say, from a police officer's point of view, there's almost no investigation nowadays where you could not imagine not to have a cooperation with a private party. Think about financial investigations, how to do it without cooperating with financial institute banks. Think about cybercrime, how to do it without online service providers, telecommunication providers. You have to cooperate with them. And there, I think, also the Europol regulation, mainly in Article 26A, 26B, was describing perfectly what Europol is allowed to do under which conditions in order to work again with this data. So a clear yes to your answer. I think the Europol regulation as it stands now brought in a lot of clarity what we are allowed to do with this data.
Okay, thank you. And I think it's important for listeners also, there are interesting concepts and definitions that we're using, but of course they all apply differently in different jurisdictions. So sensitive commercially available isn't really a term in the European Union. Also, when it comes to the jurisprudence of some courts, you know, I just want to throw in that there is additive rights infringement. So if you are using a method that is that looks very innocent at first place, it can be, if used and triangulated with another method, leads to very more profiling, and that is complicated, and we don't want to get too much into this, but I just want to throw that up. Additive rights infringement is also a thing. Thomas, the EU is renowned for much agency as regards the establishment and refinement of standards on data protection and the protection of basic rights and freedoms. We look at the GDPR, the Law Enforcement Directive, the AI Act, and the important, as you already mentioned, exemptions for national security and the various prerogatives of member states notwithstanding, there's hope that the EU can prevent, and that's now the term, sensitive data, and you can call it differently, pertaining to the core of personal life of millions of individuals to be aggregated and sold on the market. And there is a hope that this is to be prevented. Yet there are stories in Germany. There's an actor like DataRate, where you can buy 3.6 billion geolocation data for a monthly fee of 13,000 euros. There are stories in the Netherlands and in other countries where the GDPR applies. And this is obviously a complex topic, but do you have a recommendation or a request for the European Commission or the European Parliament going forward when it comes to a Europol's mandate or the EDPS review mandate regarding the competence? We already mentioned Article 17 when it comes to open source, but perhaps also Article 18 as Jürgen mentioned.
That's a lot to unpack. Limited to two things. I think Jürgen has very clearly described the benefits of having a clear legislative framework. Europol knows what they can do and what they cannot do thanks to the legislator. Yes, we have differences of interpretation, but that's precisely because there is wording which is in need of interpretation. But at least we have that wording, so that's a good thing. And if one of us disagrees and we don't find a solution, then the ultimate word will have the European Court of Justice. And that's great, because that's how democracies and the rule of law works. So I'm very happy with that. The other things you mentioned, there are many things which are still not okay when it comes to the protection of personal data, but there, I think the tools exist. The GDPR is one of those tools. It just needs to be used. You mentioned the massive collection of information on individuals, of personal data, sensitive data. I believe the tools are there, they just need to be used. And that is something for the independent supervisory authorities, that's something for the courts, that's also for administrations and public authorities to apply it and sometimes also refrain from the temptation of saying, there is data out there, I can buy it, why don't I do this? And I would say there's of course a difference to be made between commercial actors and normal public administrations and in particular the law enforcement side, because there are different purposes for different access requests. So I think that's important. And we will see the same thing for the AI and the AI Act, because there we will also have enforcement, hopefully with prohibitions and a regulation which spells out more or less what is allowed and what is not allowed. So I hope we can work on the basis of that text and then see how the enforcement works. And if it doesn't, then we probably need to add a bit more.
Thank you, Thomas. And I'm conscious of this being a very complex topic, and of course it correlates because there's one of the individual and the GDPR and how is that regulated. And if data brokers say, well, we don't process data, then we don't fall into the GDPR. Possibly there's a loophole. But then if national security and law enforcement act as clients in this regard, then this data can get into the life world of the services that rely on and the agencies. I had more questions, but I want really to open the debate to you if we can. You know, there's questions about military intelligence. How does that relate to, we heard about wars and the aggression of Russia and Ukraine, and I'm very thankful for your presentation as well. And, of course, modern military and defense means more military intelligence, and perhaps there are also data transfers between military and law enforcement, but that's maybe for another seminar. I see a question from Jaap over there. Jaap?
Yeah, thank you. So I'm Jan-Jaap Hoerdemans. I'm a Doubt Professor of Intelligence and Law at Utrecht University. I just wanted to mention, last week a paper was published on commercially available information, comparing the legislative or the recommendations from the ODNI and recommendations from March 2024 in the US, comparing to recommendations from Europe. So maybe relevant, I just want to mention. The first two questions from you about internal oversight and the ODNI were already ask, so that's great. I was just wanted a question about enforcement, also from the external oversight authorities, when recommendations are there to deal with commercially available information, and what if these procedures are not met? How can people who are involved in this do they have a remedy, basically? Are there reports about whether these recommendations are respected or not, or a different way for court proceedings? I don't know, but I'm interested to hear that from Aaron first. Thank you.
Aaron, okay.
So I think the best answer I have for you on that is that it is very multi-layered. Sometimes it's in the form of reports that either kind of spell out recommendations where we have to then respond publicly in writing as well in terms of what we're doing. Sometimes it's more conversations about recommendations and things that we need to be doing differently. Sometimes that plays out through the appropriators. GAO, the Government Accountability Office that I mentioned that does oversight, they are actually part of the legislative branch. So sometimes you'll see things reflected through what the legislature does. And some of it plays out in the court system because as a law enforcement national security entity, most of the time, we're trying to find a way towards prosecution. You know, obviously there are some national security cases that may never actually end up in a court of law. But for us, sort of what the agents are ingrained with from the time they start is kind of thinking with an eye towards prosecution. And so you can see things sort of play out through the court systems as well. So there are many different ways. Some of the internal ones, some of the ODNI ones, other things like that, those are more internal conversations and conversations at the, I'll say like the executive management level. So with the DNI and the director of the FBI, or with the White House and the other executive branch agencies. So there are a number of different ways it can play out.
Thank you. We have one more.
Yes, hi. So if I understand correctly, we have law enforcement on one side, we have national security on the other, and with different tasks and missions. But I would like to talk about another reality, which is the possible exchanges of information between law enforcement and national security. And here we can talk about possible regulations in this area, but also possible practices. So I would be very interested in hearing about a comparison on this topic between the EU and the US.
Can you say to whom you ask the question?
You want to know my personal data? Oh, no, you mean, okay, all of you. But, you know, for the US, I think we have only a single person representing.
Well, thank you for the question. Let's say when it comes to Europol, we have since almost 23 years an operational agreement existing with the United States law enforcement agencies, with which we exchange also personal related data. This is part of the personal agreement, which is then, by the way, also cross-checked with the data protection in order to also establish safeguards in order how this data can be exchanged. But our contact point are law enforcement agencies that are nominated by the US side. That is part of these agreements or arrangements we made. And with this, of course, we exchange on almost all areas, I would say, where Europol is responsible for, and you find them in Annex 1 of the Europol regulation listed. We exchange data with them in two ways. That is very relevant, also particularly in the field of counterterrorism. Clearly to say, we really depend also on a close and really good cooperation with all our law enforcement agencies of the member state, of the US. Just one example, if you look here at Europol, the biggest liaison office at Europol is the one of the United States. You find there 13 US agencies represented here at Europol. And I think they also do this because they also see the usefulness of this cooperation in both ways. And yes, to be very clear, serious and organized crime, terrorism cannot be only, let's say, tackled from a European perspective. It needs much further cooperation, which, of course, from our perspective, has to follow, and is the rallying of the European Data Protection Framework, which is rallying of our human rights and civil rights and citizen rights. This is always part of negotiations of agreements.
Thank you. Let me look at the organizers if we do have more time, because I see a slightly worrying -17 time clock here. So Jan, do we have a bit more time, or shall we? Okay, no. I thank you all for your questions. Unfortunately, in the interest of the whole conference and the further panel that we will hear, I would like to thank you all for being on this panel. It's a great discussion. I think there's room for more, and give these people a round of applause. Thank you.